Title and Risk of Loss, Chapter 23. In this chapter, we're going to understand why it's important to know when risk of loss and title pass in sales contracts. We're going to learn the concepts of title and risk of loss, and then we're going to use these concepts to determine who bears the risk of loss when goods are damaged or destroyed. Where we are. We learned the different types of property. We learned that there are ways to move property or store property without actually giving ownership of that property to the bailee. Then we looked at sales contracts. A sales contract under the UCC is a transfer of title to personal property for a price. This chapter is going to pull the concepts we've covered together. When we have Samsung, a seller, who's entered into a contract with its buyer, Target, for goods, it then has to move those goods from the manufacturer, the seller, to its buyer, who's the retailer. How does it do that? Well, the seller uses one of the special kind of bailments that we've talked about to move the goods to the buyer. Samsung might have goods stored in a warehouse, and it might want to move the goods from the warehouse to the retailer, and it would engage a carrier. While those goods are in transit, moving on the carrier from the seller to the buyer, there is the question of whose goods are they, who has insurable interest, and who is going to bear the risk of loss if something happens to the goods. Now recall, we talked about carriers have absolute liability for personal property that they are transporting unless the damage is the result of one of our 5 exceptions. So the carrier is going to be liable to one of the parties if the goods are destroyed while they are in transit. What we're looking at today are rules that tell us to whom would the carrier be responsible or liable, seller or buyer, if the goods are lost, damaged, or destroyed while they are in transit. These rules that we are going to go over are the laws provided by the UCC if the parties do not talk about these issues in their contract. If the parties decide in their contract who bears the risk of loss, who has title, who's got insurable interest, if they spell that out in their contract, then you don't need to refer to the rules that we are about to learn. But if the parties don't address those issues in their contract, then the UCC supplies an answer, and we're going to look at those answers. So some of the problems that could occur during transit are: 1, what happens if the goods are lost or destroyed? Does the buyer have to pay for the goods again if the goods are destroyed in transit? Remember, goods, personal property, that's why we can move it. When we're looking at the question of who's going to have to pay again for the goods while they're in transit, we're thinking of a concept called the risk of loss. Which party bears the risk of loss? Then, creditor's claims or seizure of goods. When can a creditor of a buyer or seller properly seize goods? So for instance, let's say Samsung is shipping goods to its buyer, Target, but Samsung has defaulted on some of its loans, and its creditors are executing liens, and they are moving to seize Samsung's goods to cover their financial loss. Well, while those goods are in transit, the creditor might think or might claim, well, they're still Samsung's, and because Samsung owes us, we can seize them. But the buyer, who's waiting on the other end of the transaction, Target is saying, oh, no, those are our goods. We're waiting on them. We've got customers. We've planned for those. You, creditor of Samsung, can't seize those goods. They're our goods. They belong to us, the buyer. Well, we have to have a concept to figure that out. Are the goods the sellers or the buyers during transit? So this goes to title. Who has title during transit? And then our third issue is insurance. Because the goods could be lost or damaged during transit, and as I mentioned earlier, carriers, although they have absolute liability for the goods that are in transit, their liability is capped by the formula that's in the bill of lading and almost never covers the full value of the goods being shipped. Somebody in the transaction is going to want to have insurance to cover the actual loss or the additional loss, excess loss, that is not covered by the carrier's contract. Well, who can do that? Which party has an insurable interest in the goods while they are in transit? So determining the rights, figuring out the answers to the questions we talked about, first begins with an identification of the goods. You cannot have rights or title or bear any risk of loss as it relates to a good until it has been identified as, I'm going to put in parentheses, as yours, but until the good has been identified. For example, let's say that you have placed an order with a store for a custom suit, and you've made a down payment on the suit, but you haven't paid it completely, and the store goes up in flames. You might, rush to the store and say, "Hey, my suit was in there. You're going to have to sell me a new suit." Well, whether or not your suit actually was destroyed is going to hinge on whether or not those goods have been identified. And we've got three categories. Existing goods would be the suit is already made and it's in the store. Then you might be able to argue that that was your suit. But future goods are goods that have not actually been created yet. And until the good is created, it cannot be identified as belonging to a buyer. And then the third category is fungible goods. And the graphic here is these blueberries, which one is indistinguishable from another, and that's the definition of fungible goods. When you have fungible goods, you have a good that you cannot identify or separate one from another. This often is relevant to like crops and commodities, minerals, food. So even though you might be purchasing pounds of blueberries from a warehouse and then blueberries are destroyed, you can't actually argue which blueberries were yours unless and until they have been set aside and identified as these particular cartons belong to this buyer. Until that has happened, you cannot have any rights to arise in you, the buyer, for the goods. Title. Title refers to ownership. So the first step in even getting on the road to creating title is the goods have to be identified. Existing goods can be identified. Fungible goods can be identified once separated and designated as someone as belonging or being marked for shipment for someone. Future goods are not identifiable. But once we have the goods identified, the question is, well, when does title, i.e. ownership, pass for those goods from the seller to the buyer? We've got three categories where we can determine when the passage of title occurs. If we have goods where there is a document of title for the goods, then, for example, a bill of lading or a warehouse receipt, that's a document of title. If you have the bill of lading, that entitles you to goods being shipped under that bill of lading. If you have a warehouse receipt, that is a document that entitles you to redeem or to retrieve the goods that are being stored in that warehouse. So if the goods that the buyer is trying to claim have a document of title with them, then as soon as the buyer receives the document of title, then title to those goods passes to the buyer. And what does that mean? Then those goods are the buyer's. The buyer owns the goods when they get the document of title. And keep that in mind because that's going to impact what we're continuing to talk about. If we have a case where there's no shipment involved, then the issue is different. Under the UCC, the seller has no obligation to ship goods to a buyer. If the buyer wants shipment, they have to have that in the contract. If the buyer and seller do not provide for shipping of the goods in the contract, then the UCC provides that the place for picking up the goods will be the seller's place of business, and if the seller has no place of business, the seller's home. So in non-shipment cases, title passes at the time that the contract is entered. All right? Title passes at the time the contract is entered if you have a non-shipment case and the buyer is picking up the goods from the seller's place of home, seller's place of business, or if they have no place of business, their home. If the goods had a document of title, then title passed to the buyer when the document of title was transferred to the buyer. These two categories are fairly easy and straightforward. The more difficult case is the delivery or shipment cases, where you have the seller who is going to use a carrier to ship the goods to the buyer. And in those situations, we will have something called FOB shipping or FOB destination. And the title is going to pass to the buyer according to the FOB designation in the contract. And that's what we're going to look at more closely. So again, passage of title can only occur after we've identified our goods. Our existing goods are easy to identify, right? Existing goods, you go in the store, you pick out the suit, you pick out the dress, you pick out the shirt. This is the one I want. The goods have been identified. If there's a non-shipment case, then title is going to pass to those identified goods to you at the time that you enter the contract. If it's future goods, then the goods cannot be identified until they actually come into existence. Future goods have not been created yet. Fungible goods are indistinguishable and therefore cannot be identified until they have been separated, carded, packaged, identified as being, designated to go to a buyer. Once that has occurred, then it's possible for title to pass to the buyer. But the title will pass depending upon if it's a document of title that's being used, like the bill of lading, a warehouse receipt, as soon as the buyer receives that document of title. If it's a non-shipment case, i.e. the parties did not put it in the contract to have the goods shipped, then the buyer will be going to the seller's place of business to pick up the goods, and the title will pass to them at the time that the contract is entered. If the seller has no place of business, then the buyer will pick up the goods at the buyer's home. If the parties put in their contract that the goods would be delivered, then title will pass depending upon the FOB designation in the contract. Risk of loss. In addition to wondering when the goods are in transit, whose goods are they, i.e. title, we also want to ask, well, who bears the risk of loss for the goods if they're lost, damaged, or destroyed? Risk of loss also follows the three categories. If we have a document of title, the risk of loss is going to pass to the buyer when the buyer receives the document of title. So this is the most simple scenario to understand. If we've got a document of title being transferred from a seller to the buyer. Then as soon as the buyer receives their document of title, like a warehouse receipt or bill of lading, then both title and risk of loss will pass to the buyer. And what does that mean? If the buyer has received the document of title electronically or through the mail before the goods actually are delivered, then those goods are already there, i.e. the buyers, upon their receipt of that document of title. So if they're damaged on their way to the buyer, those goods were the buyers, and so the buyer would have the risk of loss. So if they want more goods, replacement goods, they'd have to pay again. If they wanted those goods to be insured, they would have had to insure them because the goods belong to them because they'd already received the document of title. If we have non-shipment goods, the risk of loss passes when the goods are tendered if we have a non-merchant seller. What does this mean? Non-merchant seller. This is a person who is not in the business of selling whatever is the subject of the transaction. So let's give an example. Let's think yard sale. You go to a yard sale and you see a lawnmower that you like, and the neighbor at the yard sale offers to sell you the lawnmower for $100. They are not a merchant. They are not in the business of selling lawnmowers. They're just selling you their personal lawnmower. At the time that you all enter that contract, because there is no delivery, you haven't set delivery, this is a non-shipment case, title passes to the buyer at the time the contract is entered. So you, the purchaser, the buyer, you offer to buy the lawnmower for $100. The seller accepts. You have a contract. So the contract has been entered. Title has passed to you. You are now the owner of the lawnmower. The risk of loss will pass to you, buyer, in this non-shipment case from a non-merchant when the seller tenders the goods. Tender means to make available. So as soon as the seller makes the lawnmower available to the buyer, the risk of loss passes to the buyer as well. Now, you might assume that these would happen at the same time, and probably in most instances they will. If you're at a yard sale, which is a non-merchant, you offer to buy the lawnmower for the $100, they say deal, and the lawnmower is right there and you can take it with you at the time. You take it, you've got title, you've got risk of loss. If on the way home the lawnmower falls off your truck and another car runs over it, it's your loss. You cannot go back to the seller and say, hey, I just bought this thing, but I've already lost it, give me my money back. That won't work. Why? Because you owned it, because risk of title had passed to you when the contract was entered, and the risk of loss had passed to you when they made that lawnmower available to you to take home, i.e. tender. If you're dealing with a seller who's a merchant, the risk of loss does not pass until the goods are actually received by the buyer. You get more protection when you are a buyer purchasing from a merchant. In a non-shipment case, i.e. you go to Lowe's and you're going to buy the lawnmower. The seller is a merchant. They're in the business of selling hardware, including lawnmowers. As soon as you enter the contract, because there is no shipment, title passes to you. But the risk of loss does not pass to you as the buyer until you actually get the lawnmower. So if you place the order for the lawnmower, you go in, you're like, that's the one I want, but you don't have your truck with you that day. And you come back and to pick up the lawnmower the next day. If for some reason that lawnmower had been damaged in the warehouse while they were getting it off the top shelf, you don't have to buy the lawnmower again, even though technically title had passed to you when you entered the contract. The risk of loss had not passed because the lawnmower had not been, you had not received it as the buyer yet. Therefore, you could ask for them to give you another different lawnmower that wasn't damaged. In contrast, With the non-merchant yard sale seller, if you had not had a vehicle to take your lawnmower home, but the lawnmower had been made available for you to take it home on the day that you enter the contract, if you enter the contract with a non-merchant, they take your money, title has passed. They tender the lawnmower saying, it's here, you can take it. But you tell the non-merchant, I need to go home and get a truck. I'll be back a little later. If that lawnmower is damaged, destroyed, stolen even, before you get back, while it's still on the non-merchant seller's property, you, the buyer, will be out of luck. Because under the law, if you didn't put it in your contract, something different, the risk of loss passed to you, the buyer, in a non-shipment case with a non-merchant as soon as the goods were made available, i.e. tendered. With the merchant, you get more coverage, more safety, more protection. With the merchant, risk of loss does not pass to the buyer in a non-shipment case until the buyer actually receives the goods. With the non-merchant, risk of loss passes to the buyer as soon as they are made available. So what's the lesson in that? Buyer, if you're buying from a non-merchant, as soon as you enter the contract, you need to be prepared to take your goods home. Because if you don't, and they are damaged, you have to buy them again. The seller does not have to give you your money back. They don't have to pay for it. It's not still under their insurance. The risk of loss has passed to you, the buyer. Our last scenario is when we have delivery or shipment cases. The risk of loss is going to pass according to the FOB designation in the contract. What is FOB? Free on board. That is a terminology used in shipping. So let's look at some of the scenarios. Our first scenario, we have the seller manufacturer who's in Chicago, who is delivering their goods to the carrier, which are en route to Greensboro to our buyer, Target. In this scenario, you see that the title transfer is occurring as soon as our seller is delivering those goods to the carrier. This is referred to as FOB shipping. When you have a designation where with FOB shipping, as soon as a seller delivers the goods to the carrier, title and risk of loss transfer to the buyer. That's what FOB shipping means, that title and risk of loss transfer to the buyer at the shipping point. In this scenario, you need to look at the locations. So it would be easy if in our contract it said FOB shipping, because if it said FOB shipping, you would know, oh, okay, I as the buyer get title and risk of loss as soon as the seller puts the goods on the carrier. But that's not what the contract is going to say. It's not going to say FOB shipping. It's going to say this. It's going to say FOB Chicago. The contract is going to have FOB and then a location. And you have to be able to understand that when I look at the location, I need to know what the definition is. And so when I see FOB Chicago, that's the location of where the goods are being shipped from. So this must be FOB shipping, because it's FOB and then the location of where the shipment is coming from. And if it's FOB shipping, that means title and risk of loss transfer to the buyer at the time the goods are loaded or delivered to the carrier. FOB designation is just the opposite. Here you see we've got our seller, manufacturer still in Chicago. The goods were put on the carrier in Chicago. But in this scenario, title to the goods and risk of loss are not transferring until they actually reach our buyer who's located in Greensboro. When title and risk of loss do not transfer until they actually reach their destination, this is called FOB destination. But again, the contract's not going to say FOB destination. It's going to say something like FOB Greensboro. So you would need to read the contract and see, oh, if you're the buyer, well, we're having those goods delivered to Greensboro. I see it says FOB Greensboro in the documents. So we are getting title and risk of loss once we actually receive the goods. This is how the FOB designations let you know when title or risk of loss pass to the buyer. When you have FOB shipment, title and risk of loss pass to the buyer as soon as the seller delivers the goods to the carrier. So if the goods are damaged while on the carrier, then the carrier is going to pay their limits, that absolute liability that they've set forth in their bill of lading based upon their formula, to the buyer. If the contract is FOB destination, where title and risk of loss are transferring to the buyer upon reaching the destination of the buyer, then if the goods are damaged while in transit on the carrier is going to pay its limits in the bill of lading to the seller. And that also means the seller would have to replace the shipment and send a whole new shipment to the buyer, because those goods are still the seller's while they're in transit under FOB destination. So let's look at a few practice problems. Smith Debnam, located in Winston-Salem, sends a shipment of goods to Hunter White in Raleigh. The invoice was stamped FOB Winston-Salem. So this is all that we have. The parties have not said anything else in the contract about when title or risk of loss would pass. We just know that the goods originated in Winston and they're going to Raleigh, and the invoice was stamped FOB Winston. So what does this tell us? This must be FOB shipping. Why? Because the location is the same as where it's being shipped from. So the goods coming from Smith Debnam, the title and risk of loss transferred from them to the buyer as soon as those goods were delivered to the carrier. That's what FOB shipping means. And we can tell it's FOB shipping by looking at the location. Scott Paper Products, located in Oakland, California, sends a shipment of goods to Bryson Hardware in Wichita, Kansas. The bill of lading states FOB Kansas. FOB Kansas. So we've got our FOB, and then the designation is the location of where the goods are being delivered. So this must be FOB destination, which means that title and risk of loss will not pass to the buyer until the buyer actually receives the goods. Therefore, if these goods are damaged while they're in transit on the carrier is going to pay the limits in the bill of lading to the seller, Scott Paper. If Scott Paper has creditors who want to seize their goods, they're going to be able to, because the goods still belong to Scott Paper, because the title hadn't passed to the buyer yet. And Scott Paper has every right to place insurance on those goods. They have an insurable interest in that shipment because the goods remain theirs until they reach the destination. Thomas Built Trucks, located in Washington, sends a shipment of buses to DeKalb County Schools. The invoice is in FOB Georgia. Now, I did not mention where DeKalb County Schools is. It's a popular county name, so I assume that most of you probably know that DeKalb County is in Georgia. But there could be other DeKalb counties, right? So if you have this issue, and it's like it's a little unclear, the one thing you do know is that the seller is located in Washington, right? And so and then the FOB says Georgia. Those are two different states. So even if you're not certain that DeKalb County Schools is in Georgia, clearly the FOB is a different state than where the goods are originating from. So this must be FOB destination, which means that the seller will have title and risk of loss for the goods being shipped until they reach their destination, which is in Georgia. Starlight Glass Company, located in Massachusetts, sends a shipment of glass jars to Becky Ann's boutique in Tennessee. The receipt states FOB Massachusetts. What this means is that the title and risk of loss for the shipment of glass jars is going to transfer to the buyer, Becky Ann, as soon as those goods are delivered to the carrier, because this is an FOB shipping designation.